Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Today, me and my partner will be presenting on the case review for tort law subject. Our course code is LAWS 1340. This case review will be presenting by me myself, Siti Norsyuhada binti Mat Akhir, matrix number 2114830, and my partner Saidatul Fatihah binti Hamid, matrix number 2116260. And this case review is to submitted to Dr. Siti Norsyuhada. We will review on the case of Alah Imang at Alah Emang against Luxor Network Berhad and others.
Okay, Assalamualaikum warahmatullahi wabarakatuh. My name is Saidatul binti Hamid and my matric number is 2116260. So thank you for the Syuhada for presenting the introduction. So for my part, I will present the summary of facts of this case and the issue that arise from this case, the causal argument between the parties, and lastly is in analysis part, I will present the whether or not the legal reasoning behind the decision made by judges was correct based on the authority cited in this case.
We will review on the case of Alah Imang at Alah Emang against Luxor Network Berhad and others, 2020. This case is held in High Court in Binti and the judge is Zulkifli bin Bakarji. The introduction of the case. In this case, we will discuss more details on the area of law that whether first defendant or the second defendant is guilty in making the plaintiff suffer pain. This case is important in order to it will become one of the references for the upcoming similar cases or similar situation with this case. And it will also to give lessons to the defendant and also to those people who are liable on their product for becoming the producer, on brand or the importer of accidents happened relating to their products.
The summary of facts, the plaintiff, who is the Alah Imang or Alah Emang, sue the defendant, who is Luxor Network Berhad under the Consumer Protection Act of 1999 for personal injury caused by the first defendant's faulty product gel gamet, which is gamet topical gel. The first defendant was the distributor of the aforementioned goods, while the second defendant was the agent or promoter for the first defendant for the aforementioned items. The plaintiff claimed that as a result of the second defendant's deception, she acquired the aforementioned item from the second defendant sometime in March 2001. The plaintiff thereafter utilized that the aforementioned product resulting in discomfort and the injuries to the plaintiff. The plaintiff, however, dropped the complaint against the second defendant after he was declared bankrupt on 21 July 2005. Therefore, this case is still continuing under the swing on the first defendant. So, for the issue that arises in this case, I can recognize there are 4 issues, which is the first one is whether the first defendant as the distributor of gel gamet, gamet topical gel, which is undisputed, is vicariously responsible for the second defendant's action. Second, whether or not the second defendant as the registered distributor and agent for the first defendant, which is undisputed, sold a packet of gel gamet 120 grams per tube or per pack to the plaintiff in March 2001. Third, whether is the cause of the alleged injury, if any, to the plaintiff's ears is from the product gel gamet. And lastly, is whether the first defendant is responsible for the plaintiff in asserted injuries, damages, or costs. So moving on to the next part in the causal argument between the parties. In the plaintiff arguments, the plaintiff has testified that the plaintiff bought this product because the defendant told that this product is very effective for his ear problem. After that the plaintiff bought this product and he suffered the pain in his ear, which is the gel garment had caused the tinnitus where he suffered the ear problem. Because of this suffered, the plaintiff claimed that ototoxicity content in gel garment was the one caused the tinnitus. In addition, he also claimed to the court that the back nasal end and sophrodiax also caused the tinnitus. The plaintiff also argued that the defendant was misleading the representation in relation to gel garment, which is he suffered the ear problem. The plaintiff also relying on the Consumer Protection Act on Section 9, Section 10, Section 19, Clause 2, Section 20, and Section 67 alleged that the gel garment was defected based on this provision. In fact, also, there was a lacking on the instruction or direction use the leaflet or safety warnings in the labels written on the packet, which this argument makes strong when the defendant also was not denied for this mistake. So to rebut the plaintiff argument, in the defendant's argument, the defendant testified that gel garment was not the main reason to that several pains in the ear of the plaintiff. It is because the defendant stated that the plaintiff had suffered the ear problem earlier and even before purchasing the gel garment applied to his ear. The defendants also argued that the plaintiff witness 3, who is wife plaintiff, was avoided to answer the question, which was mainly related to the subsequent events after the morning. The defendants also stated that the statement made by the wife plaintiffs also was contrary to the plaintiff when which she said that the TB was serious pain she had ever seen suffered by her husband. The defendant also stated that the evidence that the plaintiff has received the medical treatment which proven that the plaintiff has the tinnitus even before he applied the gel garment. This is based on the evidence by the defendant witness 1 stated that they could not detect the ototoxicity in gel garment where the audiogram also used and resulted that there was no ototoxicity in the product. This evidence rebut the for-what plaintiff claim which the ototoxicity caused the pain to his ear. The defendants also testified that the defendant was not misleading the representation to the plaintiff as the plaintiff was read the brochure presenting people's testimony on the healing capabilities of garment oral jelly. And P19 Clause E is a brief introduction to the study on eye garment and its therapeutic properties, which is the defendant stated that the plaintiff could understand and not misled to the product because he already read the brochure about the product. The defendant also stated that this product has been authorized by the Ministry of Health as evidenced by the words diluluskan oleh KKM on Exhibit D1. This product gel garment contains a safe concentration of propylene glycol, which is why KKM authorized it. So this is why the defendant had success in this case because the defendant argument was strong enough was strong enough while the plaintiff was not. So going to the next judgment, which is presented by the Shuhada.
As for the judgment stated in this rule, the first issue is whether the first defendant, as the distributor of gel gamat topical gel, which is undistributed, is vicariously responsible for the second defendant's act. The relevant provision referred to are Section 9, 10, 19, Clause 2, and 20 and 67 on Consumer Protection Act 1999, the Act. The plaintiff had failed to prove that the first defendant had net false or misleading representation in relation to the gel gamat. This is the plaintiff claim to have read consist brochures containing testimonies of people on the healing properties of gamat originally and is on brief introduction on the research on air gamat and its healing properties. Therefore, if the plaintiff have read it, means that he has not been misled by gel gamat, a topical gel, because what he was read was about originally for oral consumption. His evidence on this aspect is doubtful. The plaintiff also contended that he was convinced by the label suitable for internal use on gel gamat packaging. Upon careful examination on the product, the words directions smooth on skin preceded the earlier label. The plaintiff relied to the fact that there was the lack of instruction or direction for use leaflet or safety warnings. Label writing on the packaging to warn the consumer of the usage. The defendant agreed that there were such lacking, but disagreed that the first defendant had not complied with the law, as gel gamat does not have any danger because it can apply for mouth ulcer which could be inside the mouth. The provision of the law that was relied by the plaintiff in this case does not provide for presumption of guilt on the part of first defendant to prove otherwise. The second issue is whether the second defendant is the registered distributor and agent for the first defendant, which is not disputed, did sell a packet of gel gamat, 120-gram tube or pack, to the plaintiff in March 2001. Plaintiff testified that he was first introduced to the gel gamat by second defendant sometimes in the middle of March 2001. According to him, the second defendant came to his office at MLNG office complex at Tanjung Kidurong, Bintulu, for different purposes, and by a mere coincidence, introduced to him to the said products. At this meeting, the plaintiff informed the second defendant that he has ear problems. The second defendant also testified that he became one of the distributors for first defendant's products since 1998, and he did inform the plaintiff about it in the same year. The second defendant said in his evidence that he too had the ear problems due to underwater diving. He had used gel gamat by placing the gel onto the cotton bud and apply it by inserting into the canal of the ear that was having problem. As for the second defendant, by using into gel gamat that the way he did, he had ceased to have the ear problem anymore after using it for about a week, as there was no longer water discharge from his ear that was having problem. Therefore, the issue of second defendant being agent or distributor of first defendant and did distribute or supply the first defendant's product, the gel gamat, cannot be distributed to, and the second defendant is a credible witness, as in his evidence, he did not deny that he was the agent or distributor of gel gamat for the first defendant, and he did supply the said gel gamat to the plaintiff. The only contradicting evidence between the plaintiff and the second defendant is the date or year of when did the gel gamat was supplied to or purchased by the plaintiff from the second defendant. The second defendant may be uncertain or guessing as to the date or year of 2000, and the plaintiff may be correct that the relevant date or year was March 2001. The date or year may be crucial, but it does not crucial become decisive by its nature. The third issue is what is the cause of allied injury, if any, to the plaintiff's ear. From this report, One would notice that the said gel garment contained 5% propylene glycol. However, as mentioned earlier, that the 5% contents could not have caused tinnitus to the plaintiff, and in fact, the plaintiff having tinnitus problem because he had underlying psychiatric problems, and therefore there is evidence to show that the said problem has been approved by Ministry of Health since it was written diluluskan oleh KKM. This product, gel garment, containing safe concentration of propylene glycol, and that was the reason why it was approved by KKM, Kementerian Kesihatan Malaysia. Another expert who testified and explained what is tinnitus and had with no uncertain term told this court that it is not possible for the cotton bud inserted into the ear canal of the plaintiff to cause the perforation, whether with or without gel garment applied on it, unless the cotton bud had been inserted very deep and forceful for the eardrum to be perforated. The result would be the same even with gel garment. The witness from the defendant who examined the plaintiff did not find ototoxicity, such as damage to the inner ear of the plaintiff due to toxic element. Therefore, if gel garment had in fact contained toxic elements and it was applied using the cotton bud into the ear canal of the plaintiff, surely there would be sign of ototoxicity. The last issue is whether the first defendant is responsible for the plaintiff's asserted injuries, damages, or costs. Plaintiff also contended that he was convinced by the label suitable for internal use on the product gel garment. Upon careful examination of the packaging of gel garment, the words directions, smooth onto skin, preceded the earlier label. Therefore, the court ruled that the label is not misleading and the presence of 5% concentration of propylene glycol is not harmful to ear canal of a human being that had been testified by an expert. To amplify further the above reason, there is evidence to show that the said product has been approved by Ministry of Health since on the packaging of gel garment was written diluluskan oleh KKM. This product, gel garment, containing safe concentration of propylene glycol, and that was the reason why it was approved by KKM, Kementerian Kesihatan Malaysia. Therefore, it shows that common personal care products and ear drops containing propylene glycol are freely available in the market, such products after being approved by Ministry of Health KKM would mean that gel garment is clearly suitable for internal use. Putting it in substance, the plaintiff relied to the facts that there was the lack of instructions or direction for use left lid or setting warnings labels written on the packet to warn consumers of the usage and of any potential hazards of the said product. To this issue, the court has the benefit of evidence from the general manager of the first defendant who testified that he agreed that there were such lacking, but he disagreed that the first defendant had not complied with the law because the product gel garment does not have any danger because it can apply for mouth ulcer which could be inside the mouth. The dangers or potential hazards as alleged by the plaintiff in this case is in respect of the contents of propylene glycol. Therefore, considering the evidence in totally in respect of dangerous and hazardous contents of propylene glycol in the gel garment, I agree with the general manager that such warnings are not necessary when there was none. Next, for the comment and analysis. The plaintiff had suffered with tinnitus earlier, although described as mild, even before the application of the garment into the ear canal of the plaintiff. This shows that even though if gel garment that triggered to the tinnitus to occur when it was oppositely proven, the plaintiff had already suffered tinnitus. The plaintiff should have told the defendant about the tinnitus that the plaintiff had suffered before. The plaintiff also contended that he convinced by the label suitable for internal use, but also there are words smooth onto skin preceded the earlier label. In this case, they are damage or injury occur to the plaintiff, but it was not by the act of defendant, as there are no defect in the product used and bought from the first and second defendant. As for the undisputed facts, the label is not misleading, and the presence of 5% concentration of propylene glycol used in the gel garment is not harmful to ear canal of human being. This product also was approved by Ministry of Health since its Triton degrees and olive km, as evidence shows that gel garment is clearly suitable for internal use. The plaintiff relied to the fact that there was the lack of instruction or direction for use left made or safety warnings label written on the packaging to warn the consumer of the usage. The defendant agreed that there were such lacking but disagreed that the first defendant had not complied with the law as gel garment does not have any danger because it can apply for mouth ulcer, which could be inside the mouth. These are the cases that we use and are relevant to our case.
So thank you, Syuhada, for presenting the case review. So in analysis part, I will talk about the reasoning behind the decision and whether the reasoning was correct based on the authority cited in this case. So the in this case, there are two rational descendants, which is the first one is plaintiff having failed to prove that gel garment had caused the injury as he claimed in this case. Second is the defendant was neglected to someone the rebuttal evidence showing that the 5% propylene glycol concentration was not damaging to his ear canal and could not have produced the tinnitus. So for these two reasons behind the decision, the court referred to the authority cited, which the judge used two cited case, which is the first one is Syarikat Telekom Malaysia against Business Chinese Directory Sendirian Berhad 1997, and the second is the public prosecutor against Muhammad bin Sulaiman in 1982. So we're going to look at the fact of the case cited in this case. So in Syarikat Telekom Malaysia against Business Chinese Directory Sendirian Berhad 1997, so the fact is the appellant claimed that the respondent compiled, published, printed, distributed, and sold the telephone directories in Chinese Communication Business Chinese Directory, the book, and that in doing so, the respondent obtained or copied the substantially from the telephone directories published by the appellant without their permission or authority. The appellant requested and was granted on the injunction until the trial to prevent the respondent from printing the book and to assess the damages. The plaintiff's suit was rejected with caused by the High Court. The appellant has filed an appeal. So the court held that the appellant was failed for the claim and stated that while it is true that the burden is on a party who asserts that he has sustained damages to prove that the fact this does not absolve the opposite party for adducing evidence in written. So besides relying on the case of Syarikat Telekom Malaysia, the judge just also refer to the case in public prosecutor against Muhammad bin Sulaiman in 1982. This case was related with the related and expert defender's statement could be evidence to the judge to refer for the judge to refer his judgment. So in this case, we're going to talk about the fact. In this case, it was raining, thunder, and lightning during that night when the gunfire was heard. In the morning, a bullet was recovered from the surgeon's left arm, but nobody saw who had shot him. Mr. Lam, a chemist with the government chemistry department, examined the bullet. in his conclusion, he stated that the bullet is connecting the accused, which why the accused was uh, was found guilty in this case. However, the court held that the accused was not guilty under the section 214 clause 1 I of criminal procedure code, which even though an expert defendant had give the statement, but if the judges also know the area part, so the statement made by the evidence will not relying 100% to make his judgment. So for the reason, it is the reason was made sense that the judge in this case of Alah Imang was made sense. So my answer is the reason behind the decision was correct and made sense based on the authority cited. Why? Okay. Here my reasoning why the reason behind the decision was correct, which is the first one. In this case, the plaintiff, in this case of Alah Imang, the plaintiff was failed to prove that the Jargamat caused the tinnitus, as the judge in this case referred to the judgment of Court of Appeal in Syarikat Telekom Malaysia against Business Chinese Territory, stated that while it is true that the burden is on a party who asserts that he has sustained the damages to prove the fact, this does not absolve the opposite party from adducing evidence in rebuttal, in which is clear that when the defendant when the defendant in case of Alah Imang rebut with the facts that the plaintiff has the tinnitus and ear problem even before bought the product based on plaintiff's statement. Which is this make that there is a prima facie in plaintiff evidence to show that he suffered pain in ear was caused by Jargamat was not strong enough. So apart from that, the judge also showed that an expert statement can make evidence for the judge based on case public prosecutor against Muhammad bin Sulaiman in 1982. The judge in this case used the defendant's statement as evidence whether or not the accused was guilty, even though the decision made by the court stated that the defendant was not guilty. However, in case of Alah Imang, the defendant, the judge in this case of Alah Imang, relying on an expert defendant statement as evidence in his decision, which the presence of 5% concentration of propylene glycol is not harmful to ear, which why the defendant was an expert in toxic element effect. To emphasize the point, the product also has been approved by the Ministry of Health as evidenced by the work diluluskan oleh KKM on Exhibit D1. This product Jargamat contain a safe concentration of propylene glycol, which is why KKM authorized it. This is why the reason behind the 5% concentration of propylene glycol is not harmful to ear. It is because the judge relying an expert defendant statement. So to conclude this reason, the judge in this case of Alah Imang was fair enough for me because he do not rely on witness statement only but also refer to the cited case to make his judgment clear and correct.
We move to the conclusion. The conclusion is this case is worth the review since we can get to know more into details on the principal used in this case. It also can be a supportive case in order to make decisions on further cases, so it will enlighten the process in order to reach the decision held by the court.